So the crux of the question is around the relationship between a seller of a property, a buyer of a property, and the estate agent, right? And if there are existing tenants staying on this property subjected to a lease, one needs to dig deep as to what the law says around how these relationships are managed. So the first part of the relationship that one needs to look at is between the tenant and the landlord. Now, the landlord at this moment in time was the seller. The seller sold the property and there was a tenant on the property. Now, our law has a principle referred to as hier gaat voor koop. So what that means is that a tenant actually has a right against the landlord to occupation of the property by virtue of the lease agreement. That right cannot simply be cancelled and is not terminated upon the selling of a property. So what that really means is that when a seller sells the property to a purchaser, that tenant comes along with the property, and all rights and obligations of the landlord are passed on to the new buyer. It has to be a valid lease agreement. An unlawful occupier would have no rights to the property to begin with. So when the property is sold, the right of occupation still vests with the seller. So that right of occupation can be transferred to the purchaser. In our example, the lessee or the tenant has that right of occupation. And since that right of occupation vests in the tenant, it is retained with the tenant irrespective of who the owner of the property is. I hope that